Think about the difference between the phrases, "let's eat dad" and "let's eat dad." Or in the case of this church sign, the phrase, "we love hurting people." A single missing comma transforms the entire message. In the construction industry, that exact type of ambiguity is a constant threat. A vague clause or a misplaced comma in a subcontract can trigger a multi-million-dollar legal fight over which party actually owns the project's risk. When these ambiguities surface, the industry's default response is adversarial negotiation. Both sides dig into positional bargaining, aggressively fighting to protect their narrow contractual rights without leaving any room for compromise. This approach leads straight to legal warfare. Projects stall, professional relationships turn toxic, and financial waste piles up as the focus shifts from building physical structures to battling in court. There is an alternative: structured negotiation. This is a methodical, psychology-driven process designed to resolve conflict efficiently without anyone ever setting foot in a courtroom. To fix how the industry operates, we have to look past the surface-level arguments and diagnose the 3 specific triggers that turn a simple project delay into a fatal dispute: ambiguity, power, and emotion. The first trigger is the power imbalance. Large project owners or general contractors often dictate terms to smaller subcontractors. Those smaller firms frequently accept these conditions blindly because they fear losing out on future work. This dynamic is driven by the leverage and dependence theory. The party with fewer outside options is highly dependent on the deal, which often forces them to swallow unfavorable conditions. To cure this, negotiators must assess their leverage before sitting down at the table. That means mapping out alternative options, so if Plan A and Plan B fall through, you still have a viable Plan C to rely on. Part of that preparation involves setting firm boundaries, like establishing a top 10 list of contract benchmarks. This sets clear rules for engagement, such as refusing to sign broad-form indemnity clauses or rejecting mandatory lien waivers. Sometimes the cure requires structural help. New legislation, like British Columbia's Prompt Payment Act, levels the playing field by mandating strict timelines for contractors to submit a proper invoice and for owners to actually pay it. The law also provides a fast-track adjudication process. A neutral professional makes a binding decision in a matter of weeks, removing the ability of a wealthier party to starve out a subcontractor through endless delays. By combining strategic preparation with these legislative protections, smaller firms can neutralize bullying tactics and negotiate from a position of actual strength. Even with a balanced power dynamic, humans introduce the second trigger, the psychological trap. This occurs when cognitive biases override technical data and contractual logic. One of the most common biases is reactive devaluation, the tendency to automatically distrust an offer simply because it comes from your opponent. Look at this text exchange. An accidental autocorrect to "dead husband" triggers an immediate emotional reaction that stalls the dialogue entirely. Overcoming this requires a shift from rights-based bargaining, which argues over contract clauses, to interest-based bargaining. This method looks at the underlying needs of both sides, like maintaining supply chain stability or keeping a crew employed. To make that shift, negotiators have to categorize and prioritize their targeted terms. Sorting project concerns into distinct, manageable categories helps take the emotion out of the room. The industry is also recognizing the need for better mental tools. Mindfulness and emotional intelligence training are now being integrated into negotiation courses to help professionals regulate stress and respond constructively. The cure for these psychological traps requires stripping the emotion away from the data, keeping the focus entirely on the mutual interest of finishing the build. The final trigger is the subjectivity problem. Every project has uncertainty, and disputes escalate quickly when a highly risk-tolerant personality clashes with someone who is deeply risk-averse. When these mindsets collide, their different perceptions of risk lead to unjustified escalations. People start making forceful claims or accept poor deals just to avoid the anxiety of the unknown. One way to eliminate this subjectivity is through alternative dispute resolution, specifically mediation. A neutral third party helps reframe the dispute from an argument into a structured problem-solving session. Modern tools provide an objective baseline. AI algorithms analyze contract data and calculate the financial impact of project delays across various scenarios. By using these platforms, parties assess negotiation contexts before meeting, identifying the most cost-effective path. Combining ADR with predictive AI models gives negotiators a shared set of facts, allowing data-driven projections to take precedence over subjective intuition. Practicing structured negotiation does not mean giving in to the other side. It is a hybrid strategy that pairs collaborative values with strategic assertiveness. It requires reading and understanding the contract thoroughly, actively neutralizing power imbalances, checking personal biases, and leveraging objective data. When these pieces fall into place, the entire timeline of a dispute compresses. Disagreements that used to drag through the courts for years can be resolved in weeks through fast-track adjudication and mediation. The ultimate goal is to create a sustainable ecosystem. The construction industry needs cooperation that is resilient enough to survive the massive complexity of modern building projects. By adopting these structured methodologies, professionals solve individual disputes while strengthening the industry's long-term capacity to protect the skyline and the built environment.